Tribune.
May it please the Court. My name is Travis Godwin, and along with Jessica Darno, we represent Dr. Angel Astro and Mrs. Angel Astro in the matter before you. The matter before the Court this morning is whether or not summary judgment in the lower court was proper given the Court's application of the fair report privilege, and whether or not that fair report privilege extends to non-public, unofficial documents. The underlying claim is based upon a series of articles that ran in the Sarasota Herald Tribune that asserted that Dr. Angel Astro was responsible for deficiencies in care, including miscarriages and callous treatment of patient Lonnie Hildebrand. The articles ran from August 25th through August 27th, and again on September 6th. The articles paint a picture that Dr. Angel Astro was found to have provided substandard care by a governmental authority, and we would argue that there is nothing further from the truth. The false statements contained in the article are not protected by the fair report privilege because the newspaper has argued both in the lower court and in the briefs before you that they relied on on a statement of deficiencies issued by the Agency for Healthcare Administration and the Centers for Medicaid and Medicare Services. And none of those documents was Dr. Angel Astro's name mentioned. Most importantly, we would submit to you...
But he doesn't deny he was the doctor referenced in those reports, correct?
Today, he does not deny it. He does not argue that he was one of the physicians referenced in that report. And it is also pertinent that that report doesn't mention the name of any health care providers. And it's a couple of reasons. Because both the state and federal agencies have recognized the privilege or the privacy of healthcare providers in these situations. In preliminary investigations before probable cause is found, especially with regard to healthcare provided to individuals, those doctors' names and healthcare providers' names are protected both under federal and state law. And specifically in this instance, the bottom of those documents say that these documents are not supposed to be released to the public for over 90 days. That brings into question another issue.
Really? But who is that prohibition addressed to?
To anyone. The prohibition against releasing that information, and that's an issue of fact that is before the lower court as well, and we think prevents summary judgment, is where did they get this statement of deficiencies and when? We would argue that they were not entitled to it at the time they received it, if they received it prior to the articles being published. The letter itself from the Agency for Healthcare Administration is dated August 22nd, 2011. The articles were published within 3 or 4 days after that. If you just take the facts most favorable to the non-moving party, the hospital likely did not receive that letter and statement of deficiencies until right before the article was published. But most importantly, the statements that are interwoven in the article that paint the picture of Dr. Angel Astro as being responsible for some of these care is not related to that official public document. By their own testimony and by the brief submitted to this court, they state that it was related to a letter subsequently submitted by Lonnie Hildebrand, the mother of the patient involved in the care. That letter certainly is not a public...
Wasn't that letter what initiated the... wasn't that the complaint that initiated the investigation?
We do not know that. That is still an issue of fact to be determined. And that's another chronology issue that is before this court, because that letter, by their own admission, was not part of a public record until well after the articles were published. In addition,
but they interviewed her, the author of the letter.
That even brings more subject into question. A private interview is not protected. The case law is abundantly clear that the fair report privilege, there are two theories to it, or two theories commonly used. The most common one is that the media is to serve as the public eye on public documents and public proceedings which the public cannot observe because of time constraints. A private interview between a reporter and a private citizen is not an official public proceeding, nor is it an official public document. They rely a lot on Ortega and Medco in their arguments in their brief and in the lower court. However, both of those proceedings involve sworn testimony We don't have that here. Certainly private statements and a letter, and which most importantly, the letter that was written by Ms. Hildebrandt does not mention Dr. Angel Astro by name either. And that creates another issue of fact. When was that letter part of the official record? Because, Your Honor, when investigating these types of issues, the Agency for Healthcare Administration, there are statutes that require a hospital to report certain adverse events. That could have sparked this investigation. There's no evidence before this court that that letter is, or the lower court, that that letter was what initiated the investigation, but more importantly, it doesn't mention Dr. Angel Astro's name. So those are all issues of fact that have yet to be determined that we feel through further discovery, it will reveal that it certainly was not part of the record when they claim the statement of deficiencies were issued, because the statement of deficiency does not even reference the letter. It doesn't reference any interviews, and these private statements are not protected. As I stated, they heavily rely on Ortega, which involved public statements, sworn testimony by public officials in a public proceeding. That did not occur here. What occurred here is a private citizen making innuendos and allegations that are not supported by fact. Those facts need to be further explored, because if we look at the chronology of events, when we did a discovery to them, when we said, what documents did you rely upon in creating this article, they sent us the response to a public records request to Sarasota Memorial Hospital. Well, the other prong to the fair report privilege when they're serving as the public's eye on public proceedings or public events is that they accurately report that. And they didn't do so here, because that document is narrow in scope, and it talks about and does not mention Dr. Angel Astro's name. Your Honor, I apologize. I don't know if I reserved 5 minutes.
No, but I was going to let you know.
Okay, thank you. But we would also argue that this document is in another issue of fact that needs to be explored is was it supposed to be public record? Because certainly when you have the safeguards that are put in place both by the federal government and the Florida statutes, Dr. Angel Astro's name was not to be released. And if they want to interweave the statements made by private citizens and a letter submitted by a private citizen that arguably has not been determined if it was part of that file, it falls way short. Because if they, like they communicated to us, got the ACA report from this public records request to the hospital, there was exculpatory evidence in there that must have been included or should have been included in the article. Because under the fair report privilege, you are required, the media is required to report upon the totality of those documents. So if it is argued, which we don't agree with, but if you determine that the statement of deficiencies was sufficient, but you look at what they relied upon and what they said they relied upon, which was the full ACA report that was submitted to the hospital, then they were required to look at the review by the hospital that said the care of Dr. Angel Astro was appropriate. Not one, not two, but 3 times. So there's another issue of fact that needs to be further explored in the lower court. We would also argue on the grounds of the statutory protections afforded to physician and healthcare professionals that until probable cause is found, certainly their name is deemed to be protected. I mean, if someone can just throw out defamatory statements and they deem to be part of the public record because they were thrown out to a media representative, then that flies in the face of all the protections afforded physicians under the Florida statutes and under the federal regulations. The Florida statutes are very specific with regard to what agencies are to oversee physicians and what protections are afforded to them until probable cause is found. We cited the Gannett case, which stands for that very premise, and that is that in the preliminary investigations, which we would argue, especially with regard to Dr. Angel Astro in this case, are protected. They're privileged. They're not part of the fair report privilege of which the newspaper asserts. There was also an issue of the contents of the letter and how those are interwoven and whether or not those are fair and accurate. Again, we would emphasize that all the case law that is presented to you by the newspaper involves official public proceedings of official documents. Even the case at the lower, I'm sorry.
You go ahead.
The trial court found that the articles fairly reflected what was in the public domain. And so I'm not sure whether are you taking issue with what the trial court found, or are you taking issue with the Agency for Healthcare report being part of the public?
Your Honor, we're taking...
And if the former, in what respect do you think the trial judge erred when he goes through statement by statement and says, this is consistent with what is in the public record?
Your Honor, we differ on both of those counts, and I'll address the one with the trial court first. The trial court relies on Rasmussen as citing to authority of why the statement of deficiencies is inadequate, or the article adequately restated the statement of deficiencies. The statement of deficiencies do not contain the comments of Novotny or Hildebrand, nor do they include any of the issues listed in her letter. But most importantly, in Rasmussen, which involved an official public record, it involved indictments, it involved government orders, executive orders. That is what the newspaper relied on in that instance. The individual's name was out there, and it was in public. It was in the public realm.
If the doctor's name had been mentioned, would that defeat your claim? If the doctor had been mentioned by name,
it would not have. It would not have defeated our claim, because we argue on two counts, Your Honor. We argue, one, that his name was not mentioned, so that document, A, he's protected there. But more importantly, was that a fair and accurate depiction of what was contained in the four corners of that statement of deficiency. And it isn't. The statement of deficiency...
And I think Judge Black asked you that, and that was going to be my question. How is it not an accurate reflection of what's contained in those reports?
Sure.
And I understand the point you made that, well, the report doesn't have the contents of the letter. Leave that aside. To the extent that the articles report what is in the report, how was it inaccurate?
The articles, because of the way they interweave with the comments made by the individuals, the private citizen, it's not an accurate report. Not only that, they paint the picture...
Okay, so then do I understand your argument is because they've used these other facts and interwoven it, it gives the false impression that these facts that weren't in the report were in the report? Is that really what your contention is? That
is one of our arguments, Your Honor. Yes, absolutely. But more importantly, going back to your question, if you look through the statement of deficiencies, the statement of deficiencies is geared more to the care provided at the hospital, by the hospital, and the hospital staff. There are de minimis remarks with regard to an emergency care physician. And in addition to that, the statement that is pertinent to the emergency care physician talks about the hospital's inability to provide the adequate support for him. This article, even if you say, okay, well, those specific 3 or 4 statements that are contained in the statement of deficiency should be allowed to be published. Well, A, they don't have his name, and B, the way they've interwoven them, it gives the impression to the reader, and that's our allegation, that this government agency made the ultimate determination that there was substandard care by Dr. Angel Astro, and that's just not the case. Again, this is a preliminary stage. There still remains an issue of fact, because through this process, the ACA, the Agency for Healthcare Administration, issues a statement of deficiencies. Subsequent to that, and it's even cited in the letter, the hospital is allowed to issue a plan of correction. And then the agency reviews that plan of correction. This was not final. There was no final determination. But the way the articles are written, it gives the impression, and we think that's and the case law is clear that that's an issue for the jury to decide. It's a factual issue. Do the articles adequately portray what was contained in the 4 corners of the documents? And we would say no. Even the descriptions we would say there's an issue of fact, and that precludes summary judgment. The other issue that remains, which we think is also pertinent to some of the arguments we made with regard to the fair report privilege, is privacy. Certainly, a reasonable person would think that they were going to be afforded the protections of Florida statutes that are in federal statutes that are in place at the time the article was published. Again, they've emphasized and overemphasized both in their argument in the lower court and in the court briefs that they relied on a statement of deficiency. Nowhere in there is Dr. Angel Astro's name. In fact, as I've communicated, the federal government and state governments go to great lengths until probable cause is found to include that. I can't emphasize enough that they've attempted to throw or cast the net of the fair report privilege over these private statements with private individuals. I think that is some of the most biggest and most important areas of focus. Because if you look at some of the cases we've cited, including the O'Neill case, the courts have said, look, it only pertains to that official record or that official public document. Any statements interwoven or taken by fact witnesses before it becomes an official record is not protected. This is a qualified privilege. The newspaper is attempting to expand this qualified privilege into preliminary statements of non-public officials at non-public proceedings. It shouldn't be applied here. Every issue that they talk about involves an official public record or a statement from our early case or a statement of an official public person. That didn't happen here. Ms. Novotny, who was Ms. Hildebrandt's mother, made some statements in a letter, again, issue of fact as to whether that was part of the, or accompanied the statement of deficiencies, and whether they've admitted they didn't get it until they got the full report from Sarasota Memorial Hospital. At least that's what they communicate in lower court, and that's an issue of fact. There is no way, as this case sits before this court and before the lower court, that there are no issues of disputed fact. This case is riddled with issues of disputed fact. When did the report get into the hands of the newspaper? Were they entitled to the report? Does the report accurately, do the articles accurately, reflect the contents of that report? I mean, there are fact issue after fact issue after fact issue that needs to be explored, and there still remain before the court, and therefore summary judgment was not proper.
If you want to save 5 minutes, your time.
Thank you, Your Honor.
Okay, thank you.
May it please the court, my name is Carol Cicero, and along with Rachel Fugate, we represent the Sarasota Herald Tribune and its reporter, Barbara Peters-Smith, and Ms. Smith is here today in the first row of the gallery. I'd like to take the time, because I know the court is familiar with the record, to sort of highlight what the undisputed facts in this litigation are. It is undisputed that Dr. Angel Astro was the doctor who treated Ms. Hildebrandt. He admits that in paragraph 17 of the second amended complaint, and again, Your Honor, it's admitted that Ms. Novotny's complaint letter was what started ACCA's investigations on its own behalf and on behalf of CMS. That's an admitted fact that was alleged in paragraph 19 of the second amended complaint, and both the paper and Ms. Smith admitted those two important facts, that Dr. Angel Astro was a treating physician and that Ms. Novotny's report was what started the government investigations. And you'll remember that Ms. Novotny is a co-defendant in this litigation. The actual patient, Ms. Hildebrandt, was a co-defendant in this litigation until the second amended complaint. So in the first two complaints, she was also a defendant. So those allegations, while designed probably to address Ms. Novotny and what the plaintiff may, what Dr. Angel Astro may characterize as the harm he suffered from her letter in going after Ms. Novotny, that is an undisputed fact that her letter was what generated those investigations and reports as well. With respect to the fact of what the paper had, that is equally clear. The parties entered into a stipulation regarding discovery. That's at page 374 of the record. That's where it begins. And in paragraph 1, in exchange for a mutual stay of discovery, so we didn't take discovery of them, they didn't take discovery of us, we told them, that was a condition of the stipulation, what we had at the time of the reporting. In paragraph 1 of the stipulation, we identified that we had both of the reports conducted that grew out of the investigations conducted by ACCA. So the report that ACCA did on its own behalf and the report that it did on behalf of CMS. We also had a letter that ACCA wrote to Sarasota Memorial Hospital explaining the deficiencies that were found and stating that they would also be hearing from the federal government about whether Sarasota Memorial Hospital, who is a public hospital, would be able to continue to participate and receive Medicaid and Medicare benefits. The paper also had a letter to staff, which was attached as Exhibit A to the stipulation regarding to discovery. That was a letter from the hospital to its own staff discussing the anguish that it had caused Ms. Hildebrandt and the corrective measures and the retraining that the hospital was undertaking at taxpayer expense to correct the deficiencies found by ACA. Not only was it the deficiencies found by ACA, but the hospital admits that it did its own investigation as soon as it received Ms. Novotny's letter, and that it found its own problems too, and that those problems weren't limited to Ms. Hildebrand, and that's also borne out by the ACA report. There were multiple patients that had similar issues in the ACA report, but Ms. Hildebrand was certainly the focus of the ACA reports. And the last thing that the Herald Tribune had prior to writing the articles, the 4 articles at issue, was emails exchanged by Ms. Smith, the reporter, and the hospital, mainly the public information officer for the hospital, concerning what had happened and asking about Dr. Angel Astro's status with the hospital. With respect to the letter by Ms. Novotny that starts all of this after Ms. Hildebrand's terrible experience in Sarasota Memorial, almost 3 years to the date from today, that document was written by Ms. Novotny within days of her daughter's experience. It recounts tragic events that happened and how Ms. Novotny had to deliver her grandchild, the second fetus, and I should back up for a second because we haven't talked a lot about the facts. But Ms. Hildebrand, the patient of Dr. Angel Astro, was is an insulin-dependent diabetic with a pump. She came into the hospital that day at the end of her first trimester at 13 weeks, probably thinking that things were going to be okay. She had a twin pregnancy, 2 babies, and she was experiencing all the awful signs of miscarriage, bleeding and terrible cramping, and she was in significant pain. She was admitted in the morning on July 1st of 2011, and by 6 o'clock that night she had lost both of the babies. So, and she was left alone for hours and hours. That's borne out not only by Ms. Novotny's complaint letter and what she then recounted to the paper, but by the ACA report on behalf of CMS. The CMS is, not to get too acronym oriented, but the Center for Medicare and Medicaid Services, the federal government. So Ms. Hildebrand's experience that day was tragic and awful in and of itself, even if the hospital had done everything that they could to save the babies. But that's not what's borne out by the record and what ACA found. If the court looks at page 258 through about 260 of the record on appeal, to say that ACA didn't make findings about Dr. Angel Astro is just not correct, and it's not borne out by the record. The findings concerning Dr. Angel Astro are laid out, and more importantly, what ACA concludes is that Ms. Hildebrand was neglected, and that there was a failure to provide the quality of care necessary for her. She's referred to as patient 5 in the ACA report. So at page 162 of the record, it goes through the things that weren't done for her specifically. Blood chemistry tests related to her blood sugar levels. Her blood sugar levels weren't monitored. There was a failure to initiate orders in response to increased clotting and abdominal and labor pains. There was a failure to document informed consent. And probably most importantly to the patient, there was 5, and I'm quoting, no documented interventions to stop labor. Based on those findings, ACA's ultimate conclusion is that the facility's governing board failed to ensure the ECC physician, and ECC is Emergency Care Center physician, had provided the quality of care necessary for patient number 5 as follows, and then lists what I just read to the court. And at page 259 of the record, it found that the condition of participation in Medicare was not met because the patient was not, quote, free of neglect, and the term neglect is used several times in the report. And neglect is deemed, and this wasn't even reported by the Sarasota Herald-Tribune, a form of abuse in the ACCA CMS reports. So the ACCA CMS reports deal in pretty good detail with what was laid at the feet of Dr. Angel Astro and the failures with respect to Ms. Hildebrandt that came from his care. They go on to talk about the failures with nursing, which were significant as well and only compounded the injury that Ms. Hildebrandt suffered that day when she miscarried those twin babies. The hospital goes on to explain to its staff that it was essentially horrified that by the anguish and suffering experienced by a family in their care. That's at page 376 of the record. The hospital flat out at page 376 admitted it was wrong with respect to Ms. Hildebrandt, and then goes on to talk about the investigation that it conducted independent of ACCA. So the record is replete not only with admitted facts about Dr. Angel Astro being the doctor here and the complaint letter that was recounted to Ms. Smith being part of the basis for the articles, but also the ACCA reports specifically addressed Dr. Angel Astro's behavior and failings with respect to Ms. Hildebrandt, who was referred to as patient number 5. With respect to whether the records were confidential or not, that's one of the main arguments that the plaintiffs make. The confidentiality issue is a Public Records Act exemption. If there was confidentiality of any records and they shouldn't have been released, that was an obligation borne by the state agency, borne by ACCA, borne by CMS. But we've reviewed the statutes that that Dr. Angel Astro cites related to confidentiality and do not believe that the agency even had any obligations to not produce the reports. If you look at the statute that the Dr. Angel Astro cites related to the alleged confidentiality of the ACCA report, that statute talks about probable cause. We're way beyond any kind of finding of probable cause here. The agency specifically in the record pages that we've cited, 259 to about 260, 261, makes findings. The hospital, and that is included in the record on appeal, entered into a plan of correction. Didn't dispute the findings, didn't say that any of the findings that ACCA made were wrong and have ACCA revisit them. None of that is part of the record on appeal.
Wasn't the focus of their plan of correction really largely that they needed to provide additional resources to the emergency room department and to the physicians in the emergency room department and to the nursing staff in the emergency room department? Wasn't it really focused on the resources that they allocated in that area?
Your Honor, what it's focused on is significant retraining and coordinating between what they call the upper floors of the hospital and the emergency room. There are pages and pages, dozens of pages of PowerPoints related to retraining. A lot of that does focus on the nursing care. But there was also findings that that there wasn't a sufficient connection between the obstetric floor related to here and the emergency room. And a lot of that focused on not just the care in dealing with the physical situation of the plaintiff, but the emotional care because of the anguish that Ms.
Right, in other words, they weren't providing those resources to the emergency room physician and emergency room staff.
But there wasn't any. The emergency room physician here consulted. That's part of the ACCA report. He did contact the obstetrics floor and received help. There was nothing in the record that said that the failures by Dr. Angel Astro were because he was so busy that he wasn't being helped. But didn't the report say something to the effect that the hospital failed to ensure that he was able to provide quality care? Something along the, obviously you're paraphrasing.
But
what the ACCA report did was, the ACCA report is focused on the hospital because if we're talking about the way government works, ACCA is in charge of the hospital. But the hospital obviously doesn't treat patients through anything except for human beings. And the ECC position is named in the report as having failed to do 5 main things, and then ultimately being found to have been the source of the neglect that was put at the feet of the hospital, because that's who ACA regulates. There may have been other investigations going on. Department of Health, Dr. Angel Astro talks a lot about what the Department of Health did or did not do with respect to him, but whatever the Department of Health did or did not do is not part of the record on appeal. That is the agency that deals with licensing physicians, but what they did is not revealed here. So, and if you look at the Carson case, which is a case out of the 5th DCA that we've cited in our papers, I think that answers what the court may be thinking about here. In the Carson case, you had one public record, which was an unemployment compensation record. What the paper, the Daytona Beach News Journal, did was it reported on one portion of the report, which dealt with why Mr. Carson, who was a political candidate, was fired. It did not deal with the remainder of the report, which was whether he was awarded unemployment compensation benefits, and whether and the fact that he wasn't found to have engaged in misconduct that would have disqualified him for the unemployment compensation benefits. And when Mr. Carson sued the paper, he was upset about the fact that the paper reported about his discharge without saying, and oh, by the way, he wasn't found to have to have committed misconduct, and he was awarded unemployment compensation benefits. And what the 5th DCA said was, you can focus on the portion of that public record that's dealing with the issue you're covering, the discharge. You, paper, are not required, in order to take advantage of the privilege, to have reported on everything else that was in the report. So the fair and accurate, the fair report privilege doesn't require a newspaper to even report on every detail of a single document. Here, we certainly didn't have to report on not only what ACA did or what CMS did or didn't do, but what the Department of Health did or didn't do, which wasn't available and isn't part of the record. So yes, Your Honor, ACA does regulate the hospital, but there's nothing in the ACA report that makes a finding that but for failures to provide sufficient emergency room doctors, the Dr. Angel Astro would not have done these things. It lays the blame for much of what happened to Ms. Hildebrandt that day at his feet, in addition to the nursing staff, who also didn't do right by her. And a lot of what you see in the corrective plan of action and in the record about what the hospital did was related to retraining nursing staff. But with respect to confidentiality, the records here, the public records here, are not confidential under the relevant statute in Chapter 395. And the federal regulation concerning CMS records says within 90 days. It doesn't say the report has to be released. It doesn't say it cannot be released for 90 days. It gives you an outside time frame. But what's more important, Your Honor, is not whether the record should have been kept confidential by ACA or not. What the United States Supreme Court has said in the Bartnicki case that we cited to the court, in BJF versus Florida Star, which we have cited to the court, what the Florida Supreme Court did in the Hitchner case is basically said that when you receive records from government, even if they're confidential, a paper cannot be civilly liable for reporting on those records. BJF versus Florida Star involved a rape victim's name being inadvertently disclosed by a government agency to the paper, and the Florida Star reported that woman's name. There's also a Florida statute that prohibits and criminalizes publication. That was found unconstitutional. It was in the public record. It was unfortunate, but there was no privacy claim related to the disclosure of the rape victim's name. In the Hitchner case, confidential child abuse records for HRS, now DCF, that were false accusations against the parents of a child. And the court in the Hitchner case, the Florida Supreme Court, didn't find a privacy claim because the records were released, even though they should have been confidential. And there are many cases that we have cited in our papers that reiterate that proposition. What's important here is that the paper reported on multiple government actions, services provided by a public hospital to a patient who came to that public hospital seeking help, investigations conducted by that public hospital of itself, investigations that were triggered by a letter that the...
But you didn't have the letter, and I think you started to get into this and then
Sure.
and digressed into something else, but you didn't have the letter. What you had was an interview. And you're trying to fit under the fair reporting privilege, the fact that you had this interview with the person who wrote the letter, and ultimately this letter was the genesis of the investigation. Am I understanding correct? That's how you're trying to get to the privilege?
That's part of it, Your Honor. We think that the letter provides certain details that flush out what ACA saw and what the patient reported, and that served as the basis for the investigation. But the reporting here, I mean, this situation has basically been decided by a sister court in the Ortega case. And in the Ortega case, there was congressional testimony about money laundering and an individual, Mr. Ortega, being a front for that operation. He wasn't named, just like Dr. Angel Astro wasn't named in the ACA report. And a reporter got not a first-hand account from the witness who actually testified before Congress, but a second-hand account from a staffer saying, this is what he testified to, and this is what the public records say. So in the Ortega case, when the reporter for the TV station reported that Mr. Ortega was a front for money laundering, he wasn't doing that based on having heard the congressional testimony. He didn't have the transcript, and Mr. Ortega griped about that mightily to the 3rd DCA. But the 3rd DCA found that it was still an accurate summary of what had happened in a public proceeding and of public records. And that's what happened here. We didn't have Ms. Novotny's letter before the stories, even though we were apparently copied on it. That's part of the record. What Ms. Smith did was she interviewed Ms. Novotny and Ms. Hildebrandt. They recounted what Ms. Hildebrandt complained about in her letter, which was a first-hand recounting. It was confirmed by Ms. Hildebrandt, the patient, and it was also confirmed by ACA. And
I think their response is this wasn't a public proceeding that she was reporting on.
It was a public. If I misspoke, this was not a public. In Ortega, there was a public proceeding and public letters.
I think you're trying to make that distinction.
Well, I don't think it's valid. I mean, in Ortega, there was both a proceeding and records, and in this case, there are records, and you get a first-hand accounting of the complaint letter from the woman who wrote the complaint letter that everyone knows and is part of the admitted facts, triggered investigations where there were findings consistent with what she was complaining about. In addition to what I read about the failures of Dr. Angel Astro, the CMS report lays out kind of hour by hour her experiences. That's around about page 255 of the record. And many of those experiences and the time and the lapse between getting help, getting tests for her blood sugar, Ms. Hildebrandt's blood sugar levels, that's the kind of stuff that Ms. Novotny complains about in her complaint letter. She thought she was losing her daughter that day. And she was left alone for hours, and Ms. Novotny had to deliver the baby, the second baby, and they lost the first baby in the procedure that there wasn't documented informed consent for. So, you know, whether the court relies on the ACA report itself or includes the complaint letter and the ACA report, the record bears out the story that Ms. Novotny and Ms. Hildebrandt tell Ms. Smith. It's tied to both of those records. And if you look at the White case versus Fraternal Order of Police that we also cite in our proceedings, that case basically addresses this issue. There were complaints by a police benevolent association that were later investigated, and the court said, the D.C. Circuit, how can we say that it's fair to report on the investigation and not the complaint that triggered it? And that's exactly what's going on here. How can we say that it's fair to report on what ACA on its own behalf, on behalf of CMS, what Sarasota Memorial, a public taxpayer-funded hospital, investigated and found, but stated it's not fair to report on the complaint letter that triggered it, or the recounting of the complaint letter that was accurate by Ms. Hildebrand and Ms. Novotny, who was the author of the complaint letter.
Okay, thank you.
Thank you very much. We would ask that you affirm the lower court.
Thank you.
Can I approach you?
Yes.
Your Honor, the counsel for the newspaper goes to great lengths to walk you through the actual statement of deficiencies. But as Your Honor articulated, nowhere in that statement of deficiencies does it talk about or blame specifically Dr. Angel Astro, and it certainly doesn't list his name. In fact, in the statement of deficiencies, it says the facility's governing body failed to ensure that the physician had provided was provided with the necessary support. So we would argue that that just it enhances our position that the Agency for Healthcare Administration did not find fault on behalf of Dr. Angel Astro. In addition to that, the counsel for the newspaper has stated that the letter, which they admit was not in their possession, should be protected by the fair report privilege, and that it just elaborates on what was found in the Agency for Healthcare Administration, statement of deficiencies. However, nowhere in there is it talked about the patient being left alone for hours, the fetus is being placed in a bucket, Dr. Angel Astro not neglecting the patient because he was speaking with a Baker-acted drunk. That is not part of the report that they deemed to rely on.
Well, let me just ask you a question. But
Sure.
you know, one of the statements that she just made reflecting on the White case, that look, how is it not fair to report on the incident that generated the investigation if you can report on the investigation?
Well, there's two reasons why it's not fair. The White case we can differentiate in that the comments that generated that were from public employees, public officials on a public record. And in this instance, Dr. Angel Astro is a private individual. And
working in a public hospital.
He's working in a public hospital, but there are specific safeguards, as even recognized by the report that they say they base their story on, where his name is not mentioned. But more importantly, Dr. Angel Astro is afforded the understanding that his care was not called into question as it was in White. And they didn't have copies of the complaint letter. The complaint letter, even to this date, is deemed confidential. There's no argument about that. The only reason that they got the complaint letter was from the Sarasota Memorial Hospital file that when they did a public records request. And that was inadvertently leaked. The issue still remains, and there are issues of fact that need to be further explored in the lower court as to, is this an accurate depiction of what they had at the time the articles were published? The Schiavone case that we cite in our brief says, look, you can't retroactively run around and find some public records to support defamation articles that are already...
I don't dispute that they had interviewed Ms. Novotny.
I don't dispute that. Well, the fact is, when did they interview her? We don't know that, and that's another fact that needs to be explored. But even if they did interview her, that interview...
You're contending that they included her statements in the articles.
But my point is, Your Honor, we haven't conceded to that, but you make a very valid point. But even if they interviewed her interviews, in the case that they emphasize is the Ortega case, involved sworn testimony. The case law is clear that an interview of a private citizen and a facts witnesses does not give the rise to a judicial proceeding or sworn testimony. That means anyone could say anything about anybody, and it's fair game. That could be the subject of a bar complaint. Someone could assert that I did something wrong, and I've got and the newspaper can publish an article on that. That's not true. There are safeguards put into place specifically for that reason, because the fair report privilege has in order for it to come into play, it has to be on a public document, public testimony, official public record. It was designed to allow the media to serve in the eyes of the public and monitor government proceedings. The White case is the monitoring of a government proceedings. It's the monitoring of police operations. This case here involves a private citizen whose name wasn't listed in the report that they say they relied upon, and they didn't have the letter that interweaves. That's another thing that you should focus on, is how they interweave these statements from these interviews of private citizens that are clearly not protected with assertions that they say are directly from the statement of deficiencies. The interweaving of these statements and the painting of a picture that the federal or state government has deemed the care rendered by Dr. Angel Astro as inappropriate, callous, and that he performed all these acts is just not protected under fair report privilege. It's not a true and factual depiction of that document.
Thank you, sir.
Thank you.
All right. Our next case this morning, Elge versus Krensk.
I think someone left something at the podium.
The last one.
Oh, that's fine. I'm sorry.
Never